Hello, everybody. Hello, Auntie M. Hi, C-Rex, my love. Hello, Nana Laura. Good to see you, sweetie. Oh my gosh, I have some fun for tonight. Yes. This poor judge. She's so patient. God bless her. Oh, my heart breaks for her. It really does. Defendants not listening, talking over her, thinking they know better. Oh, I get kisses. I know. I'll throw something at you. I'll get you. I'll send Ava to wake you up. Yep. You can't see her, but she's right here. Billy makes a better door than a window. Oh, well, the good news is we can get right into it. I won't make you guys stay up waiting for long. I'll give Ava her treats really super quick. Hi, Colette McCoy, sweetie. You missed us because I had to take the night off. I edited a video, and while it was exporting, I promptly passed out. I woke up about 12:30 in the morning. I usually go live sometime between 10:30 and 11. And I woke up about 12:30 in the morning, and I was like, crap. Everybody's probably already asleep. I thought about coming on. I really did. But nope, she's got a whole bag. I can't give her too many of them too fast because they've got marrow in them. And, it's kind of a natural Hey, Sean. Good to see you, sweetheart. What was I going to say? I had a thought. Hey, don't you smack my dog. I really did have a thought. Hey, quit that. I know. He's so jealous. Which one? Billy, Ava, or me? All of the above. Oh, I remember. Okay. So the merch store, we're having some technical difficulties / growing pains with it. I don't want to get too deeply in it because I'll get all ragey and stuff. But long story short, eBay has this weird rule where every new seller, apparently, their store is taken down to make them call in and verify that they're a real person. Now, I personally think this policy is BS, and there's a better way. But who am I, to throw logic in the, into the mix? So, anyways, they took the store down once. I called in, I verified, I'm a real person, and the graphic designs they're really the channels. And so they put the store back up. I went to go get the link this morning and it was gone again. So I called back in. They put it back up. They said another reviewer had gone in to check the store after it was reestablished, and they decided that that I couldn't be real. You know, they think the PAWFURM is, you know, just some clever little hoax to fakely sell things. I don't know. So I'm giving them one more chance. If they, I mean, the truth of it is the link is on every video, and I don't really want to go back and have to take the link off of every video because I don't want people watching, you know, replay crew stuff from, you know, this whole past month and clicking on something that doesn't exist. So I'm giving them one more chance, and I have to relist everything. So there's nothing on there at the moment. I'm going to be kind of trying to multitask while the video's going and trying to put stuff back up. So just letting you know that that's what's going on with it. It'll be up in a day or so. And I really strongly encourage everybody to go check it out. We've got some really great things. I added pet bandanas that have Ava Fan Club on them with the AFC logo. There's a Ragey Smash Plate that is a ceramic plaque that you can have sitting on your desk or on your mantle or whatever in your office. So when things just get too tough, you've got something to take it out on. There is, there's the Quap mug and Quap shirts. The Ava Fan Club hoodies. There's the Night Shift with April logo shirts. There's lots of stuff, and there's more coming. You know, we've got lots of stuff that we're working on, but, you know, designing stuff takes a minute. So, I promise, no lies told. Oh, Colette's dropping a tickin'. Yeah, that's kind of how I feel about the whole mess. Oh, golly. Like, it was so much. I only had about half the items relisted from the first time. Like, I wasn't going to say anything. I was like, no, I'm not going to draw attention to it. Just going to let it pass. They made whatever policy reason that they have, whatever. It is what it is, right? But the second time, in less than a week's time, come on. That's a lot of work. And then to minimize it, when I mentioned, I only had half my stuff relisted from the first time. And the guy's response was, well, you have less than 50 items. It shouldn't take that long. Okay, sir. And you do it. Mr. Magical Buttons over there. You click them. Oy. Yes. Auntie M made Post-its, and she's working on a few more. For very obvious reasons, I cannot make that as merch. However, we are making, I've been to the law library. That's definitely coming. And my motto, slogan, whatever you want to call it, that's been mine for 18 years. Entire communities change one person at a time. That needs to be made. That's non-negotiable. That's coming. Oh, be safe, please. I mean, I thought it was bad enough that we get like thunderstorm warnings and tornado warnings and watches, and you know, in the winter time we get those wonderful -50 to -70. Yes, I am not exaggerating. -70 wind chill here in Wisconsin about every February. I thought those were all bad enough. I can't imagine living somewhere where you were where a fire weather watch was a thing. That's awful. I'm sorry. All right, guys. I'm going to get this on. Oh, you know what I forgot to do? I just love that. That's like my happy moment every night right there. Yes, Earl. Earl, it's okay. I promise. Okay, Ava. Yes, it's okay. No kitties were harmed in the making of the intro.
I wanted to take care of is there are several motions to seal on the calendar for the tenant is Virgil Griffin. Is Virgil Griffin here?
Yes, Your Honor, I'm here, Your Honor.
Okay. And is Mr. Dara here?
Good morning, Your Honor. Ashley Martin for the plaintiff. All of these cases were already dismissed to my knowledge.
They were. He filed motions to seal in each one of them. I was going to see if you guys have no objection to me sealing them. I can just go ahead and do those orders. I'm just going to.
Yeah, we don't have any objection at this time, Your Honor.
Perfect. Okay, so that's going to be positions number. There's several of them, so let me go back and make sure. So that's going to be position number 3, position number 5, position number 6, and I believe that is all. All right, so Mr. Griffith,
Yes,
all of those motions that you filed in each one of those cases, I will do an order to permanently. There's no objection from the other side, so I will go ahead and grant your motion. I'll make sure those orders get into your file today. Okay.
Yes, Your Honor, and I really appreciate it. And one more thing, Your Honor, the reason that I did that, I fly for UPS Airlines, and the property that I was at, they didn't have a online portal. So I would fly out of country, so I didn't have any reason. That's why I was like, they was very uncooperative. So that's why I did it, Your Honor.
Okay. All right. Well, okay. So, but at your terms of your motion, all your cases have been dismissed, and now we're going to seal them.
Okay.
Issues with that anymore. Okay, sir.
Thank you, Your Honor.
You're free to go. Have a nice day.
You too, Your Honor.
Okay. Position number 11, O'Kelly and Saroran Attorneys versus Daryl Edwards.
David Richards for the plaintiff, Your Honor.
Okay. Is Daryl Edwards here? Daryl Edwards?
I'm here.
Okay, great. All right. So, Mr. Edwards, that you should be getting a link from Mr. Richards to go into breakout room number 11. Okay.
All right.
All right. Quick.
Your Honor, on position 11, it's not a consent, but it's kind of we need the court to be involved. It's not a trial. It's probably going to be a continuance, but on position 11 with Daryl Edwards,
Okay.
there was a prior case and order, case number 24D07945.
Okay.
And there was an order, and what's going on is Mr. Edwards rented the property with another person. Only he's the only one on the lease. Maka Pope was at the time living in the property. The court issued an order resetting the hearing and ordering Ms. Pope to make payment, absolving Mr. Edwards of monetary liability. And
Mr. Edwards, can you please turn your camera on? Thank you.
Hey, I'm
and
sorry.
then and then if Ms. Pope fails, then there would be either enter into a lease or pay the rent. Then a writ would issue. But our client, for some reason, advised us to dismiss the case. So we did. However, there's an order. So whether a dismissal is effective on an order, Mr. Edwards is raising the question of whether the
Mr. Edwards, I gotta have you in the camera, sir. And
Oh, okay.
please put the cigarette out. Thanks. Okay.
Okay.
All right. So let me look at this previous case, he just said the landlord not giving proper notice. So the previous order, so long and the short of it, what are you guys saying needs to happen? Or
he can't get the people that are living there now. Miss Pope is not living there, but he's tried. The tenant has tried to get them out with the sheriff. The sheriff won't intervene. So if the court is of the opinion that our dismissal was effective, then we're going to just ask for a reset while we try to figure out how to get these people out of the property.
the dismissal on the older case?
Yes.
Hold on one second. And then what about this case that we're
We
here on?
would ask for a continuance
Continue
Well-
it, and then
while we try to figure out how to get, they're essentially squatting on the,
so you've already Mr. Edwards, you've already gotten out of there, and other people are in there now.
Yes, I've been gone, ma'am. Your Honor.
Do you know the people that are in there?
Yes, I rented the home. I rented the home. It was my ex-girlfriend and her children, and I rented the home. But back on February 10th, it was just a big ordeal, and so I left the home basically for my safety, and I made an arrangement with Miss Pope, because I didn't want her and her kids to not have nowhere to stay. So I told her as long as she pays the rent, I wouldn't, be involved, and they can have the home, and I would just stay away from it until, let the lease play out. But in March, the rent didn't get paid on time. So Invitation Homes, they sent the warrant out for to come to court. So once
So
we
are
got
you
in
on the
court,
lease? Are you still on the lease or no?
yes, ma'am. So on April 15th, when we were in the court, Judge McNeil ordered Ms. Pope to pay April and May's rent, because I hadn't been there since February. She ordered Maker to pay April and May's rent. And
This
be
is on the
gone.
current case or on the old
Oh.
case?
That was on the old case. I didn't know about this current case until like last week, because Invitation Home, they was gonna grant me an early termination. And so they told me that they would have someone go out after May 30th.
It almost sounds like this case needs to be dismissed too, and maybe it's a John Doe? No? Maybe?
Well, what it was
Well,
Invitation.
I guess I'm asking Mr. Richards what he thinks.
well, we're not sure. We have the lease has not been terminated with Mr. Edwards.
Mr. Edwards.
The only glitch really is this order that kind of absolves him of monetary liability for the property.
Yeah.
And he doesn't want to writ on his record, but this may end up being what we do. That's what the continuance will allow us to do, is to figure out what to do, whether it's dismiss and file
A John Doe maybe, and just kind of get the
Yeah.
occupants out of there.
The police apparently will not remove them from the property.
Okay. All right. So why don't we do that? Let's continue the case. How long do you guys think you need?
Say a couple of weeks. We will.
This is why you don't ever leave a property with your name still on the lease that you are not living at, no matter how much you know the person that you're leaving in the hands of. Just don't do it. Don't.
2 weeks, we would have a decision. We'll work with, I've given Mr. Edwards my contact information, and we'll confer with my client and my colleagues and figure out
Okay.
how to proceed.
2 weeks. Yeah, so that would be the 26th.
That's yes, Your Honor.
That work? You have a preference for 9 or 1?
I do not, Mr. Edwards.
No, I don't.
Okay, well, we'll just put it on the 9 o'clock then. So we'll reset this to another virtual calendar, 6/26.
Can I ask you something, Judge?
Yes.
As far as that one that got dismissed, and as far, well, this case right here. So, like I was saying, when I called Invitation Homes on June 3rd, because they were going to grant me the early termination, but they say they went to the home. But well, first of all, they had said that everybody needed to be vacated before they could do it. So when they went to the home on June 3rd, not on June 3rd, I think it was like May something, someone forged my name and said they were me. So I did a lot of calling, and this one I found out about this case right here, but someone answered this warrant under a false name, under a Destiny Edwards. I don't know of a Destiny Edwards, never heard of a Destiny Edwards. And so basically, I'm just bringing that up because they were going to give me an early termination if the order from the last court date, which was she paid the May rent and be gone by May 31st, she moved out like in the middle of May, but she left her son there with the squatters.
Okay. All right. See, I hear you. Like, so we're going to reset this 2 weeks. Hopefully you guys can figure out a way to resolve this. And, if not, we'll figure out what to do when you come back on the 26th. Okay.
All right.
Does that sound good? Okay. All right. We'll come back again. You'll get notice in the same way you got notice. Well, you didn't get notice for this one, did you, Mr.?
No, because I'm a truck driver. I've been out here on the road, so it would be email. The second one, I didn't get notice.
Okay. So do you know how to use the chat function?
Not for notice, no.
I mean, use a chat function to send Miss Harper your email address so she can make sure it's in the system.
I see where it says chat. I guess I could.
If you go to chat, you should be able to see Miss Harper and send her a direct message with your email on it.
Okay. All right. I'll do that right now.
Okay. All right. So Miss Harper, if you could please make sure Mr. Edwards is, signed up for e-service. I guess he sent it to everybody. If you could just make sure he's signed up for e-service so he gets notice of the next. But again, regardless, Mr. Edwards, your next case is going to be, the next court date is the 26th of June. Okay, at 9 o'clock.
And I'll get the meeting and the passcode through email.
If for some reason something messes up, just call the clerk's office and they'll make sure you get it. Okay, but you definitely will be on next on the 26th. Okay.
All right.
All right. You're free to go, sir. Have a nice day.
All right.
Your Honor, that's my last case. Maybe dismissed.
Yes, thank you.
He better hope that he's not on the hook for all of the damages those squatters do. Because you know darn well they're not taking care of the place. They don't care. It's not theirs. They're not on the lease. What does it matter to them? Oh, man.
Thank you.
Judge Goran, just a quick announcement. On position 7, we do need a short hearing on that case. This is a reset for the third occasion, Your Honor. So at this point, we've given it another shot. I think we do need a 10-minute, 15 minutes hearing on this.
Okay. All right. Well, let me do these consents real quick. Mr. Michelle is here. I keep trying to call you Mr. Wilder, but I know that's not your name. Okay. All right. It looks like, so I had read through the pleadings on this. I guess essentially Mr. Michelle was arguing that he was entitled to an option to purchase the property for a first refusal or something along those lines. Am I correct in that?
Judge, in essence, and I do have 2 witnesses here as well. This is a commercial property, Your Honor. this is owned at this juncture time by my client, the plaintiff, Mrs. McKelvey. Yes, there is a commercial contract for lease, Your Honor, which part of that contract has an option to purchase. Nonetheless, Your Honor, prior to this matter, as far as tenant is concerned, exercising that option, my client terminated the lease due to some violations of code enforcement. So some 9 months was given time to cure the defaults, at which time the defaults still persisted, Your Honor. My client was forced at some juncture of time to issue termination. Unfortunately, my client has also been forced to go into multiple hearings with City of Stonecrest due to the nature of the violations that persisted. The commercial tenant, Mr. Michelle, has been aware and appraised of the situation on hand by code enforcers, and subsequently he failed to cure the issues, and ultimately termination was given. At some point later on, Your Honor, and we've sent in all our exhibits, and I'm happy to introduce them into record through our witness. At some point, after the lease was terminated, Mr. Michel has sent a letter as to his intent to exercise the option. That said, the language of the option, we would argue that doesn't cover his request at this juncture time. Nonetheless, to the extent that he's interested to sell at this point in time, he's committed violations that my client is unfortunately has had to pay fines to Studio Stonecrest. And for that reason, Your Honor, we're seeking to get back possession. To the extent that he has any issues on title, he wants to bring claims as to a specific performance. All of those are which are not within the jurisdiction of this court, Your Honor. And at this juncture of time, you're not aware of, we've not been served any notices as to any kinds of proceedings in Superior Court pertaining to any kind of specific performance or any other suit. And to the extent that he wants to argue those, he can argue them in Superior Court. But as of today, Your Honor, what's before this court is our issues pertaining to the commercial lease breach, termination of the lease. There's at this point in time no contract in place, and he's a tenant of sufferance, and we're seeking possession of the premises.
Okay, you're not seeking any sort of money judgment?
No, Your Honor, we're seeking possession.
Just possession only? Okay.
Yeah, they just want you gone.
All right, so Mr. Michel, what we'll be doing, if you'd like to give me a very brief summary of your, just a very brief one, okay? Just a very brief opening statement. I'll hear your general argument, and then how it goes is because Mr. Namat is the petitioner, or his client is the petitioner, they will go first. You'll have an opportunity to ask his witnesses questions once they're done testifying. Then it will be your opportunity to testify on your own behalf, and then Mr. Namat will have an opportunity to ask you questions. Okay.
Okay. Can I speak now?
All right. Is that your last case?
I do have one question, Your Honor, and I do apologize for being stuck in Fulton. Did position 2 appear? It was a motion to seal my for Annetta Daniels.
We did not seal. If you don't have an opposition to it, I'll probably just go ahead and seal it. If you
We do. That's why I
if you have
asked.
an opposition.
It was not initially my case, but my client had sent me a message and asked me to cover it. So we do oppose it. There's still a balance owed, and there was a set out.
Okay, so okay, she did not appear. So if there's an objection, I will not grant it.
All right. Thank you, Your Honor. May I be excused?
Yes, thank you.
All right. Thank you.
Okay. I'm being here in this property for almost 9 years. And but I was here when I know the lawyer was talking about the citation, and this was previously here before I get started in the property. So for the purchase, like I got this letter. I know the lawyer has it too. It was on March 1st. And then when I write the letter to Miss Clavel so I can purchase the property. So Miss Clavel is responding me right now, March 1st, on a text. Okay. And she telling me like, okay, to maintain the purchase must contain the sale price of $450,000 along with the down payment to be held by attorney, and then with the certified fund. And then I respond to her, okay, I will get the appraisal get started by tomorrow. It was on March 1st. So the letter that they sent me to like for termination, this one is writing on 5th, on March 5. So I still want to buy the property. The thing is,
Okay.
the problem just started when they start selling the property. They put the property for sale. Okay, so they refuse to sell me the property. I am ready to buy the property, but for some reason they refuse to sell me the property.
Okay. Why are you entitled to them selling it to you? Why
Because
sell it to you?
say it again.
Why are they required to sell it to you from you're saying they have to sell it to you. Why do they have to sell it to you and not anybody else?
No, because it's on the list. Because I got an option to purchase. It's gonna be expired on May 2025.
Okay. All right. So that's what you're basing it on, that there was an option in the lease that you should be given
Yes.
opportunity. Okay.
And I
That's
wrote her a letter saying I want to buy the property. So the citation she's talking about, and she's just telling telling me about the citation, but I never see the citation. She never
Okay.
sent me anything.
all right. So this is just brief opening. I'm just trying to get an idea from what you guys want to do in the case. Just briefly before we get into actual testimony, who's testifying in this case? And if you could unmute, is it Miss McCleskey? Who are your witnesses, Mr. Demont?
Yes, Your Honor. Our real estate agent, Mrs. Vanna, is one of the witnesses, and I will just have very brief couple of questions for Mrs. McKelvey.
So it's Miss McKelvey and who else?
Mrs. Mahoney.
Mahoney. Okay, so Miss Mahoney, Miss McClevey, and Mr. Michelle is already unmuted. If you could all unmute and please raise your right hands. There we go. All right. Do you all swear, Mr. Michelle?
Yes. Oh, yes.
All right. Do you all swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
I do.
Yes.
All right. Thank you. You can all put your hands down now. All right. If we could put Mr. Edwards back in the waiting room while he's still walking, it's a little distracting. All right. If we could go ahead, Mr. Mott, go ahead.
Yes, Your Honor. We're gonna call for our first witness, Mrs. Mahoney.
Okay.
Mrs. Mahoney, can you hear me?
Yes.
All right. Would you state your name for the record?
Vanaphone Sisavon Mahoney.
And reminder that you're still under oath. Mrs. Mahoney, I'm going to show you a couple of documents. These documents have been shared with the court as well as the opposing party. So, Judge, just to be sure, is it okay if I share my screen?
Yes, please.
Mrs. Mahoney, I'm showing you what's been marked as Plaintiff Exhibit A. Again, this has been previously shared with the court and Mrs. Michelle. Is this a true and accurate copy of the lease that it's subject of this property?
Yes.
And to best of your knowledge, this lease consists of the pages that I'm showing you. This is the entire copy of the lease. Ending with the executions at the last page.
Yes.
Judge, would like to enter into evidence what's been marked as Plaintiff Exhibit A. That is the lease between the parties.
Mr. Michelle, do you have any legal objection to this document coming into evidence?
Yeah, this is it. This is it.
Okay. So no objection. It's admitted.
No objection.
Thank you, Judge. Mrs. Vaughn, I'm about to show you what's been marked as Plaintiff Exhibit B. Is this a true and accurate copy of the citations that the tenant as well as Mrs. McKelvey received around November 7th of 2023? Mrs. Vana, I'm going to repeat the question again. Do you recognize this document?
Yes, I do. That was emailed from the code enforcer.
So this is a true and accurate copy of the code enforcement violations that the city issued on this property. Is that correct?
Correct.
Judge, we'd like to enter into evidence what's been marked as Plaintiff Exhibit 3, which is true and accurate copy of the code enforcement violations from City of Stonecrest.
Mr. Michelle, do you have any legal objections to P2?
Objection, because I never see that before. And then nobody told me about it.
Okay, well, you can testify about that in a minute, but that's not a legal objection. Do you have a legal
Okay.
objection? Okay.
No.
Mrs. Vana, I'm about to show you what's been marked as Plaintiff Exhibit C. Is this a true and accurate copy of the notice that landlord issued to the tenant on or about sometime in March 5th?
That was one of them, yes.
So this is one of the notices that was issued, and this is a true and accurate copy of the notice that was issued on March 5th, correct?
Correct.
Judge, we'd like to enter into evidence the termination notice.
I got an objection for this.
Okay, hold on a second. Okay. What is your objection, Mr. Michelle?
Okay, this one is illegal
Okay.
because I spoke to Ms. Clavel, that was on March 1st, and then she agreed to sell me the property. And then I tell her,
Mr. Michelle, that's not a legal objection to the admission of the document. Okay, you can testify about the document, but you.
okay,
Okay.
all right.
Not to mention that that doesn't make it illegal. Just because she decided not to sell you the property doesn't invalidate the documentation.
All right. That was sent on March 5th.
So, Mrs. Vana, this is a true and accurate copy of it. Judge, would like to enter evidence what has been marked Exhibit C, Plaintiff's Exhibit C.
Okay. It's admitted over objection. I'm not real clear. How is Ms. Mahoney associated with this property?
Judge, Mrs. Mahoney is the agent that is in charge of management / sale of the property. She has firsthand knowledge of all the notices and the rights between the parties.
So she's the property manager?
She's the property manager / agent, Your Honor. She's assisting Mrs. McKelvey with regards to this property, Your Honor.
Okay.
And Judge, we'd like to enter into evidence as well. What's been marked as Plaintiff Exhibit D. I'm going to show it and ask a few questions to Mrs. Vana. Mrs. Vana, do you recognize this document?
Yes, I do.
And is this pertaining to the plea that your client, Mrs. McKelvey, also has entered as to citation issues?
Yes.
Judge, we'd like to enter into evidence.
These don't look like they're signed, though.
And I'm happy to put Mrs. McKelvey on the stand as far as, her knowledge of signing of those.
Okay.
We do have a signed copy as well, Your Honor.
Okay, I think you'd probably need to have a signed one, but do you have any objection, Mr. Michelle, to these documents coming into evidence?
No.
Oh, okay, no objection. So I guess they're in.
Thank you, Judge. Judge, we will also like to enter into evidence what's been marked as Plaintiff Exhibit E. I'm going to share my screen momentarily. This is Mrs. Vana. This is also the citation pertaining to the other charge. Do you recall this document?
Yes.
Judge, would like to enter into evidence what's been marked as Plaintiff Exhibit E, plea and abstention.
Any objection, Mr. Michelle?
No.
Okay. They're admitted.
And Judge, I'm gonna just ask a couple of questions, just if I may, just real quick. From Mrs. Vana. Mrs. Vana, is it correct that you've been assisting Mrs. McKelvey with regards to running and sale of this property?
Yes.
And is it your understanding that sometime in November of last year, the city issued citations pertaining to this property?
Yes.
No
Did-
objection.
Go
You
ahead.
good?
I'm not sure what, like, you can testify in a moment. Which, if you have a legal objection, you can make it, but
Okay, so, but no legal
okay,
objection.
okay.
And is it your understanding that did Mr. Michelle cure these citations or these issues underlying City of Stonecrest's concerns, Mrs. Varna?
Per my visual observance, it has not been completely satisfied, no.
And is it your understanding that at some point, let me ask this differently, did you and Ms. Clovell provide Mr. Michelle with an understanding of these citations and issues that needed to be fixed and cured?
I know Ms. Clavell did, along with the code enforcement did.
And to the best of your knowledge, Exhibit C that was introduced into the evidence earlier, was this one of the notices that was sent out pertaining to the dispute between landlord and tenant on this matter?
Yes,
And with regards to the current moment of time, it's your testimony that it has not yet been fixed from your visual observation, correct?
correct.
Judge, no further questions for this witness.
Okay. All right, so Mr. Michelle, if you have any questions, again, this is not your chance to testify yet, but if you have any questions for Ms. Mahoney, you can ask her now.
You say only question?
Just for now, you'll have a chance to testify later, but if you have questions for her, you can ask her now.
The only question that I have for Ms. Mahoney. So did you see the letter that I sent you to purchase the property?
Judge, that is outside, our objection is that this is outside the scope of direct.
I think he's allowed to ask it. It's a central issue to the case. Go ahead.
Did I see it by email? Yes.
So what was the date of it when I sent the letter?
I don't recall unless I look back, but if you're saying it's March 1st, then I guess it's March 1st. I have to go back and look.
Okay. No question.
Okay. All right. So that looks like there's no further on cross on that. Mr. Namad, do you have another witness?
Yes, Judge. We'll have Mrs. McKelvin, Mrs. Cloville.
Okay.
Mrs. Cloville, would you raise your right hand? You've already raised your right hand, so just a reminder that you're still under oath. What is your role with the property, Mrs. McKelvey?
I am the owner of the property.
And tell the court a little bit more about the issues between you and tenant as it comes down to these citations.
In May of last year, I told the tenant that I would be setting the property up for sale. He, at that time, told me he was not in a position to purchase, so I listed it and had Vanna represent me. He was aware at that time that the property was for sale, that just to clear that issue up. He has been notified by both code enforcement and me about the code enforcement issues. I even went so far as to send a tow truck there on 3 occasions to remove the vehicles that were improperly parked. And he would not allow them to move the cars and called me and told me if I moved them, that I would be essentially stealing them because they were his customers' cars. So I told the tow truck driver to stand down and I left that alone.
You
I
felt
have tried to mediate or remediate the issues for code enforcement and have not been allowed the access to do so. The tenant has been fighting me at every juncture. I would not have minded selling him the property if he had the money and could show proof that he had the money. He never showed proof. We told him he'd have to show proof because we had a buyer in the standby. Now the buyer has been waiting since March, trying to buy this property. My husband has died. He's not able to do anything more for me. And I am in Florida and am unable to travel. So there's no more that I can do to upkeep the property aside from what I've done. And Mr. Michel has been telling me he never knew about it. And the code enforcement officer is talks to him all the time. So I don't see how he didn't know about it. He has not had a business license since he started there. He has never shown me proof of insurance as we required in the lease. There are so many things that he has not done that the lease required him to do that I had no more choice but to set aside the lease. I mean, I didn't want to do that, but that's what I have to do because I can't afford the costs.
So Mrs. McKelvey, the notice that was previously showed to the court and entered into evidence, is that the notice you sent out with regards to lease termination?
Yes, it is.
And did you also, how did you send that to the tenant?
We had that served on his door, or we put it on the door because he didn't he didn't respond to the mail.
So you sent him via mail as well as you put
We
it
put
on.
it on the door of his home, and we put it on the door of the shop. So we made sure that there was a copy there for him.
What are you sir? She just said exactly what you had said, that it was on the door.
I
And-
had Mrs. Mahoney take care of that.
Now, I'm showing you what's been marked as Plaintiff Exhibit G. Is this a true and signed copy of the plea and abstention that you've entered into with the city of Stonecrest?
Yes, it is.
Have you paid fines pertaining to the violations of the occupant?
Yes, I have.
How much in value have you paid in fines in total?
Recently, I paid $445, which was a reduction of the $1,100 fee that they were requiring.
And Judge, would like to enter into evidence what's been marked as Plaintiff Exhibit G.
Mr. Michel, any objection?
Yes. The objection that I have, and when I have this property, and this property was, where the car was.
Okay, Mr. Michel, it's got to be, again, legal objection. You can testify about the document when it's your turn.
Okay, no legal
Okay,
objection.
all right. I'm not sure where we're at. Hold on. Key E is admitted.
Thank you, Judge. Mrs. McKelvey, at this point in time, has Mr. Michel sent you any appraisals of the property?
He has not.
Has he sent you any document pertaining to his proof of funding?
He has not.
Has he sent you any date pertaining to the closing?
He has not.
When did you start marketing the property?
May of last year.
Did you inform him that the property was to be marketed?
I did.
And did he at
And
any
so did Mrs. Mahoney at that time.
and did at any point in time from May of last year until the time that you sent in the termination, did he send you or take any action pertaining to fulfilling any desire to purchase the property?
Nothing until I told him that I was going to be setting aside his lease at the end of April.
And at the time that you sent out the notice in March,
I
Did
mean,
you-
in March, I'm sorry.
And at the time you sent out the notice that you mentioned earlier, you sent out in March, those violations pertaining to Stonecrest, where they're still persisting?
Yes, they were.
Judge, no further questions for this witness.
Okay, all right. All right, thank you for your patience, everyone, on that trial. I just wanted to get some of the folks that had quick stuff, let them go. So if we can go ahead, I think we just concluded. Mr. Ellis, I got to get to you. Yours is not super quick. I'm going to get to you after this hearing, okay?
Well, ma'am, I'm curious as to why I'm still waiting.
Okay, we're proceeding with this other case at the moment. I think we concluded with Ms. McCluskey's testimony. We can go ahead. Is that correct? Did you have any other questions, Mr. Namat?
Your Honor, we finished our direct, and if Mr. Michelle has any questions, then we would reserve the right to redirect.
Okay, so Mr. Michelle, do you have any questions for Ms. McCluskey?
Okay.
McKelvey.
Yeah. Okay. The question that I have, and what is the date when you have contract on the property?
I'm not sure of the date, but I've had contract on the property. It's been renewed 5 times already.
I just want to know the last contract that you had, the date of the last contract.
The last one was May 28th. We extended it to the end of June.
Okay. So did you receive the email and the text that I sent you that was on March 1st? And when you agreed to sell me the property?
If you recall, I did not agree to sell you the property, Wilder. I told you the property was under contract, and you told me, set it aside. I said, that's laughable because you're asking me to set aside a contract.
Can you answer my question, please?
She's
I am
answering. So let her
answering
finish.
I asked you, how could you ask me to set aside a binding contract for sale when you're telling me I can't set aside your contract for lease? So, it's the same thing. I offered you the property before I even put it up for sale, and you told me you were not in a position to purchase.
I never
And I
said.
have all of that. I have all of that in the text messages, which I have kept and can provide you with.
Okay, the last text message that I have with you that was on March 1st, it was 7:39 p.m. And when you agreed to sell me the property, and also you said my rent must remain current as we go through this process. So I got this on my paper right here. And then
I have an objection, to the extent that Mr. Michelle would like to go over a document that hasn't been entered into.
Yeah, you're going to have to enter them into evidence, Mr. Michelle.
say it again.
You're going to have to present your case. You have to enter your documents into evidence.
Okay, but I was at the court physically with the evidence, but just because Miss Clavell wasn't there, and then now they reset the schedule for today. So I have all this proof right here in
You
my
have to
hand.
submit it in the proper manner.
Okay.
If you can share your screen, you can show us these documents, but otherwise I'm not going to be able to look at them.
Okay, so they're all here. And also,
Okay, I can't, sir, you have to be able to share them on your screen. I can't see them like that.
so maybe we're gonna have to have another hearing because I got all this proof here, and even her lawyer make picture of them.
Who requested the virtual? Who requested that this be virtual?
The lawyer.
I did because I'm in Florida. I can't travel.
Okay.
So Judge, I would answer the questions, Mrs. McKelvey. So Judge, this matter was first set on an electronic 6 p.m. calendar. Then subsequent to that, this is, a commercial case that I think I wouldn't recall exactly. I think it was Judge Davis, but it was the inclination of the court to set it for morning calendar. We did request a virtual access for my client. She's an elderly disabled individual that lives in the state of Florida. It was granted in that same hearing. Nonetheless, when we did have the actual notice come out, it didn't include any way of access by virtual or remote scheduling for Mrs. McKelvey. Then subsequently, we filed a motion, and in the second hearing, which was in person, we couldn't get the technology to work to have Mrs. McKelvey testify. So then subsequently, the notice went out, and Mr. Michelle also got the notice in court as to Zoom details of how to go about sending evidence.
Did you send in your evidence to the court as the instructions on your notice, sir?
This one, no.
Okay, well, I can't see if you didn't submit it the way, there are instructions for submitting evidence that are attached to your court notice.
Okay,
If you
so
didn't send it in, then we're not gonna be. I'm not gonna be-
I didn't see that because I got them here. So
Okay,
I
well,
didn't.
what can I mean, if you didn't read the notice, I don't know what to tell you.
Okay, but I got all the evidence here.
Okay, if you didn't, sir, if you didn't submit it, I'm not gonna be able to look at it.
Okay, so maybe we can set up another here so I can.
No,
present
this has been reset 3 times already.
right, but it wasn't my
It's
fault last time.
clear. There are clear instructions on the notice on how to submit evidence, Mr. Michelle.
Yes, but and also the lawyer has the picture. He made the picture last time when we were at the meeting at the court. He made the picture, all the evidence. We shared.
Judge, so here's the thing. Mr. Michelle has one last page of a text message. To the extent that I took a picture, it was about another notice, but I do not have a copy of these information. Nevertheless, for the court to be able to review them, it has to be entered into the evidence per the Magistrate Court rules and Justice Civil Practice Act. Unfortunately, I also don't have them personally because there's a little bit of a gap in access to technology in a little bit, and I didn't get a copy of it neither. So to the extent that Mr. Michelle would like to enter it into evidence, we're happy to to go with that, Your Honor. But having him read it off of the record is a little bit prejudicial to my client.
Okay,
And
so
also, Your Honor. Oh, I'm sorry.
based on that, I mean, so what happened last time you were in court? The Zoom wouldn't work. It wasn't.
Yes, Your Honor. The issue was there was no way of enabling Mrs. McKelvey to have access to microphone and video.
Was that on her end or on the court's end?
On the court's end.
Because it was here, it was at 1200 C, 9 a.m.
Yes,
I mean,
Judge.
we can try again. I could reset it to in person one more time and see if we can have her log in virtually.
Thank you.
Please don't.
Thank
Your
you.
Honor, based on our experience, it didn't seem based on Judge Edgerton remarks that there was a way to do a hybrid of that kind.
I've done it. I mean, it's worked before. I mean, I know it's possible. I personally can't do it, but I know that we have had people appear on the screen in the courtroom. We've done that once, at least once or twice. I don't know why it didn't work on that particular day.
Judge Gorenz, as to the text messages that Mr. Michelle is referring to, all of that aside, this is ultimately a dispute about the contract, and the contract itself would speak for itself. My client has unfortunately had to expend 3 separate hearings, and would appreciate.
Why don't we do this? Can you scan, Mr. Michelle, can you scan
Yes.
and email in those things right now?
I don't have a scanner. And also Judge, but the lawyer said he had those picture and he left them. So it's not even my fault right now. That's his fault. Because he left the picture.
This is your case, and it's your burden to submit whatever evidence you want us to
On
see.
this thing. Yes.
So,
It's not my fault that I didn't submit the evidence. it's not my fault because the attorney took a picture and he's not willing to present it right now. That's not my fault. Everything is not this guy's fault.
I mean, if you don't have a scanner, I don't know what, and you didn't follow, I mean, you should have submitted everything you wanted us to see as per the instructions on the notice
Yeah, maybe I can.
to be ready for today. So it's my inclination. So Mr. Nama, I mean, I guess we can just if you don't have any, if you already know what he's about to read and can respond to it, do you have any objection to him just reading it?
Yeah,
Your
I can
Honor.
read them. I can read them.
Okay, Mr. Michelle, hold on. Mr. Namat, what were you going to say?
Judge, obviously that's up to the discretion of the court, and to the extent that fairness would
I
require.
mean, it's not legal. I mean, but if you're, I'm
You can have
trying
an
to,
objection
nobody
to-
wants to reschedule it for various reasons.
No.
I'm sort of in a rock and a hard place here. I mean, if, you know,
Your Honor, we'll leave it up to court, but we do still have a maintaining our objection because it wouldn't be the entire record. And Michelle and I discussed in a 2-hour window of time that we had to get a lot of different things. I personally don't have recollection of those text messages.
okay, well, why don't we, unless you guys want to have this continued again,
Oh,
I don't
So,
know.
Your Honor, if that's the options we have, again, we leave that out to the court. And to the extent that we can avoid a continuance, we would like to, continue on with the matter. So if the court is inclined to hear from him, based on just his reading of the record, that's fine as well, Your Honor.
Judge, you really have zero obligation, none, to allow him to proceed without having submitted his evidence. You don't have to allow him alternative methods of getting his evidence in. It actually goes against court procedure and rules. Just put your foot down.
I'm gonna take a 5-second break. Hold on. Okay. All right, folks, I'm not gonna do a continuance. Mr. Michelle, I'm sorry, but you did not submit the evidence that you're trying to put in the proper manner, even though you had sufficient time to do so. So I'm not going to have you read whatever that is into
I'm
evidence.
sorry, George. Is any way I can make a picture doing it on my cell phone?
No. You should have had this already sent in. You've had plenty of time, numerous opportunities, or plenty of time to have that done.
Right, I understand that, but I thought it was like
Okay.
a physical court. Yeah,
All
that's
right,
what I
so
thought.
we can move on to the next subject. Mr. Michelle, do you have any more questions for Miss McCleskey?
Okay. The question that I have, just is about the letter that I sent her. Okay, but she said she had a contract on May, and then on March 1st, and she agreed to sell me the property. And then soon as I mentioned,
Are you asking her questions, or are you done asking her questions?
yeah, I'm done with questions.
Okay, all right. So since you're done with the questions, then it's now your opportunity to go ahead and testify. You can go ahead and do that now.
Okay, yes. So and on May and on March 1st, and then when I worked out later and to Miss Mahoney, and she said, okay, I have to send a letter, like a certified letter, to Miss Clavel. And then I went to the post office and I sent her the letter.
Letter?
And
What
then,
letter? What are you referring to?
like I'm ready to buy the property.
Another letter that's not in evidence.
You
Okay,
sent her
like-
when on March 1st?
Like a certified letter, yes. And then the letter is just returning to me, and let's say return to sender unclaimed. That's when she didn't claim the letter. So on March 1st, when I call her and when I text her, and she sent me the text, said, okay, so make sure your rent is current so you can do the process to buy the property. And then when I sent her the next text, I sent her, I said, by tomorrow, I already spoke to appraisal. The appraiser said, okay, they're gonna get back to me. This is the letter they sent me. That was on March 4th. And then the appraiser said they're gonna charge me like $2,800 to do the appraisal. And then when I sent her the text, I said, okay, I'm waiting on the appraisal because on the page 21 on the contract, I mean on number 21 on the contract, and we both have to present our own appraisal. So when I mentioned the appraisal, she never get back to me, never since. And the last time she spoke to me, that was on March 24th, March 25th, I'm sorry. She responded to me. So, and then she's telling me, okay, she got a bunch of citation. I said, okay, but they should give me the citation because I'm on the property. So show me the citation. She never did. And when I spoke to the law enforcement guy, he said the property is a M2, but he's not required to pave the property. But the only thing we have to do, just put the fence on the property. That's all. And then, so when I spoke to the son, Dorian, and I tell Dorian, okay, this is what we have to do. And I told Ms. Clavel, so we have to fence the property. But they say they don't want to do it. But the property is not my own property because I already spent a lot of money on this property. I built a garage on the property on my own money. And I make a side of fence on my own money because all the property is big because I can't fence it for myself. I told them, okay, this is why the citation coming from. If we fence the property and we have no problem, but they don't want to spend no money. So right now I'm struggling since March. My wife had cancer. So everybody's just like, I'm the only one working in my family. I'm the only one. I got like 4 kids. So since March, I'm having a lot of problems. I can't even work. So right now I'm right there on the office. I can't even work. So I tell Ms. Covell, okay, if you sell me the property, I am ready to pay the fine. This right there on the text. And she refused to sell me the property. Because I never see before, Judge. I never see the citation at all. But the only thing I spoke to the officer and he said, why can't you fence the property? I'm pretty sure they tell Ms. Covell that too. That's the only thing that we need to do. Fence the property and then we never have no issue, no citation because it's a M2. That's the code for the property, M2. So you don't need to be like a gravel or anything, just fence it. So I am ready to buy the property. Okay, but the lawyer told me, okay, they're gonna give me like 3 months. So where can I find property right now? It's not easy to find property. Okay, and then also in this area, so they don't want the automotive. So I'm ready to buy the property. And also I said, okay, why you don't want to sell me the property? I am ready to buy it. So the problem is the appraisal. I already know that. Even the lawyer know, everybody know that that's the appraisal. Because the value of the property, the price they asked me, so when they appraise the property, it's not gonna be the same price that they want to sell it. So that's when the problem starts. But it's not my fault. It's reading right there on the page on the number 21. We both have to come with our own appraisal. And when I talked to Miss Mahoney about that too, and she said, yeah, so you have to get your own appraisal to buy the property. That was on March 1st. So how come right now you got a contract on May 20 something? Because you agreed to sell me the property and it was on March 1st. So the only thing I said, I'm ready to buy the property. The last thing I said, if she don't want to sell me the property, she's gonna have to pay me the other 2 years that I have. because to find a place, because I can't find no place right now. Because I got a right to buy it because it's gonna be expired on May 25th, the option to purchase. So it's not my fault because I never been late anyway. But the last letter she sent me, Judge, and also she do something illegal anyway. She went to my house. I don't know. I mean, Dogen, her son, go to my house and tape letter on my door. And my wife just gets shocked. He said, why? What are they gonna do? Eviction on us? So what happened? The house not yours? So what's going on? Because everybody gets shocked. And then my wife, she's not healthy. So all this pressure, on me, on her. But last time she fell and go to the hospital, almost get her eye going. So I'm really sick and tired with that.
Okay.
And so your wife falling is also her fault? Because it's caused you so much stress that your wife fell?
All right, Mr. Namont, do you have any questions for Mr. Michelle?
Yes, Mr. Michelle, you mentioned that you spoke to the officer who gave the citations, and he advised you that the issue was with the fence earlier on. You testified. Can you tell the court a little bit more about when that took place? Do you recall about what day in which month you spoke to that officer?
I don't really remember because this guy come often, but the problem that he has is in the back. That her son was previously ranked. Okay, because when I come to the property, so this place over there in the back, they already ranked by Doyen. Okay, so when I come get the property, the full position of the property, and Doyen said, okay, I have to get money from those guys in the back. So when the problem start, I say, okay, guys, so we're gonna close that until we get fenced. Until we fence the property. Okay, because I spoke to him. Okay, the only problem we have is the fence. If they fence the property, we'll never have any problem with the cars parking.
So would it be fair to say it was sometime in 2023 that you spoke to the officer, and it's your testimony that he came by there quite often, it looks like?
It's not 2023. I think it's sometime this year. I spoke to him. As a matter of fact, I spent a lot of money to clean all the mess, same the old man made, because I find him here when I come to the property. Same was here. I don't know the deal that they have with Sam, but the last problem that I have, I'll try to clean the property, and they look for evidence. They look like a lot of evidence, like a trick, and then so they can kick me out from the property. And they tell Sam, Dorian tells Sam, do not clean the property. So when he's about to leave, you tell him, don't clean the property. So the property is already sold. Don't clean it. I said, why he told you that? Because we tried to clean the property. But I'm pretty sure they leave they tell the old man to leave all the trash so they can come on me, and so you guys can have evidence that I'm not maintaining the property.
So Michelle, if you can just answer the questions I asked you, I would greatly appreciate it. So pertaining to the officer, he came in multiple times. It looks like you guys discussed the issue and he suggested to you what needed to be done. Why didn't you fix those issues?
Okay, first of all, he told me, so the back, okay, all the car in the back, so need to be moved. That's what I did. I tell the guy to move all the cars. They already moved all the cars. So right now I don't have any more issue in the property. He came here yesterday. He was here yesterday. Okay, so I don't have any other issue. The property is clean.
Now, earlier, my client testified that they sent you a termination notice. You've also testified that you got it in multiple ways. At this time, have you got an appraisal done on this property?
Say it again.
Have you done an appraisal on this property?
Look, she didn't give me a chance. Look, we talked on March 1st, okay, and then on the same March, on March 4th, and then I text her. I said, okay, so I'm waiting on the appraisal, okay, because the appraiser have to come to me and check everything in the area and give me like he already gave me a estimate how much it's gonna cost. Okay, it was gonna be 2,800. It's right there, 2,800. And then, but he said he's gonna take like 20 business day, so they can the appraisal can be complete. But ever since I say that, I keep calling Miss Clavell. She never answered the phone. I called Miss Vanna or Mahoney, so they never answered the phone call. The last time that she answered my phone call, that was on May 25th. And then she texting me, said, we already have a contract. I said, Miss Clavell, we cannot, you have a contract with somebody else, but you already have a word with me that you're gonna sell me the property. So right now, when she never answered the phone, because I'm scared like to spend like 2,800. I'm scared to spend 2,800 for nothing. You know what I mean?
All
But
right, so
I have this letter right here.
Mr. Michelle,
Yes, ma'am.
okay. You keep referring to the documents that you haven't sent in. Mr. Mott, so you did not have the appraisal finished because you were afraid that you weren't going to get to use it. You didn't do the appraisal. Okay.
Yes.
All right. That's what he was asking you. If you had the appraisal, that's what he was asking you.
Yes.
Okay. So, okay. No, the answer to that is no. Okay.
And to the extent of your knowledge, Mr. Michelle, you haven't also hired a title insurance, have you? Is that
Do I have to answer that?
Let me repeat the question. Have you hired a title insurance agent? Have you done a title search?
Do I have to answer that?
Yes, sir. You do. Why wouldn't you? I mean, what legal objection do you have to responding to that?
Okay. So yes, I have a insurance right.
Are you referring to just general liability insurance?
For the property?
What
Or for
insurance?
myself? For my garage? Yes, I do have for my garage.
So my question relates to a title insurance or title search. Have you hired an agent to do title search for you?
Oh, title search for the property?
Yes.
For this property?
Yes, that is what he's asking. Yes.
Yeah, that's what I have that. That's the appraisal. I already hired him. So I mean, I would try to hire him for that, but I couldn't do it because she didn't answer my phone call.
Oh, yes, I already hired him. The one that you didn't pay because you were worried that if you paid it, you wouldn't get to buy the property. But the whole reason you didn't get to buy the property was because you didn't pay those things. Am I missing something?
So your answer to the appraisal is you have not hired one. And is it your answer that you've not hired a title agent? Is that fair to say?
That's what I'm saying. I was hired him, but just because I didn't get contact with Ms. Clavell, even Ms. Vanna for a while. So right now I don't even know what to do because it's $2,800.
And is it fair to say that you also haven't hired a closing agent, closing attorney?
I don't understand that.
Is it also fair to say you haven't secured financing for the property?
What do you mean security financing? Like you're talking about like provider loan? That's what you mean?
To have financing lined up to pay for.
Have you been approved for a loan to buy this property?
I do have it.
Have you have a loan lined up and approved, ready to go?
I got cash. I got cash.
You were going to buy the property in cash?
In cash, yes.
Okay.
$450,000 in cash.
All right.
You just mentioned, Mr. Michelle, that you've been having financing and financial issues because of your wife's health issues. You just mentioned a little earlier. You testified. How much in cash have you lined up for the purchase of this property?
Let me tell you that. So that's what I'm saying. Financial, you can't have a problem to get money if you want to rent something. But if you want to buy, you will get the money. That's why I got a provider. So to buy the property.
So you're confident that you can get a financing, but you don't have the means yet.
I have it. I'm ready to buy it. That's what I'm saying. I am ready to buy the property.
Mr. Misha, just a couple more questions. I'm about to show you what has already been entered into evidence. Judge, if I may just share my screen real quick. This is Plaintiff Exhibit 1. This is the lease. You mentioned this is a true and accurate copy of your lease. I would like to take you to Section 19, use and occupancy provision. Use and occupation. Is it fair to say you also agreed to carry your business in a way that it would comply with all ordinances based on your lease?
What is that?
Mr. Michelle, do you see Section 19
Yeah, I see it.
and also Section 20 dealing with issues pertaining to ordinances? Question for you is, when you became aware of the officer repeatedly coming to the premises, why didn't you take proper action to fix the issues prior to
So
termination?
what was the issue? Because he never told me anything about issue. The only thing that he told me, move cars and make the fence. That's all. We don't have no safety issue in the property. And the property is not a, it's not a, this property need to be teared down anyway. So if I buy it, I'm gonna tear it down, the property. I mean the building.
Now you mentioned, go ahead.
There's no safety issue.
Now, if I may go to my next question, you mentioned that you mailed the notice that you sent out on March 1st. When did you mail it out? Is it correct that you sent out sometime later in March?
Actually, I email it because when I'm trying to speak with Miss Clavell, and she telling me, okay, Vanna is responsible for everything, so I have to call Vanna. Okay, so for anything. So when I called, I emailed Vanna the letter. Okay, so and then Vanna told me, okay, I have to certify it. That's when it was like on March 13 when I certified the letter.
So you sent the letter on March 13th via mail.
But Vanna has it since on March. Let me see. Yeah, Vanna has it since March 1st. She had it in March 1st when I emailed it to her.
Now I'm about to show you also Section 27B. Are you aware that your contract would have requires you 27B to go ahead and exercise the option within 45 days of the notice? At this juncture of time, you've also testified that you haven't hired an appraisal, you haven't hired title agents, you haven't hired a closing attorney.
You say 45 days?
Yes, Mr. Michelle. Section 27.B. If it is your contention that you would like to purchase the property, why haven't you taken any action pertaining to effectuating a sale?
Well, so I do it when I know, because they have to let me know that. You know what I mean? I did it when I know it. But the fact is, even
Michelle, let me stop you for a second.
Okay.
Plesky asked, she testified earlier that before she put the place on the market, that she approached you about buying the property, and you told her that you were not in a position to purchase the property.
I didn't say that. I said the price was high because she asked 700,000. That's what I told her. I told her
did you affirmatively say you were going to buy the property at that time, or did you say you're not going to buy it at that time?
Yeah, I was gonna buy it. because when I spoke to Vanna gave me
You tell her that you were gonna buy it.
yes,
You said, don't, and then so, but she just put it on the market anyway for no reason.
right. That's she the by the time the property wasn't in the market, because I can't find property anywhere in the market, but they put the sign on it. Even you search for it, you can't find it. So that's the reason everywhere where I go, they say they can't find the property for sale. So they can't find it at all. It wasn't in the
Okay, that's
market.
not, I'm asking, so you're denying that she offered you the property before she put it on the market to other people. You're saying that's not true.
No, she told me that. She told me that. Yes, she did tell me.
And
But she asked
she
me like
said that you
700.
told her that you were not in a position to buy the property at that time.
Yes, I said that to her on that time.
Okay, all right.
But
So she
the
offered
property
you,
was
said you were not able to buy it.
no.
And then she
I
put it
said
on the market.
I said I am trying to get the money. That's why I told her that. Give me some time. I'm gonna try to get the money, because she asked me like 700,000. But by the time, for the appraisal,
Okay. All right.
Judge, if no further questions, at this juncture, Your Honor, based on the testimony that we've heard, it's become evident that Mr. Michel has not taken any steps towards fulfilling any option. And to the extent that any option rights existed, condition precedent of that, Your Honor, based on the lease itself, the clause that gave him the right to have an option, Section 21. It starts with, Your Honor, saying, provided the tenant is not currently in default in the performance of any term of this lease. Now, Your Honor, Section 19 and 20 also discussed the terms of use of the premises, and it was appeared also from testimony that Mr. Michel was appraised of ordinance issues. He was visited multiple times by officer. He had discussed it with them. On March 5th, he also got the notice of termination pertaining to the lease itself. To the extent that he's brought any issues of an option to purchase, our contention would be that the clause itself is clearly saying when you're in default, you don't have the option to begin with. Now, to the extent that he wants to take the position that he has tried to exercise some kind of option right, again, that same contract, Your Honor, that he's relying to Section 27B, give a 45 days window of time from the time that the purchaser wants to exercise the option to go ahead and carry out certain terms that a routine sale has in it, get an appraisal. Mr. Michel is contesting the value that Mrs. McKelvey has put on the real estate. Well, the contract already specifies that each party can have their own value by way of having their own appraisals. Mr. Michel was on the duty to hire an appraisal and continue with the terms if he in fact wanted to assert that defense here today, Your Honor. He has not done any of that. He has not hired a closing agent. He has not hired a closing attorney, a title agent, appraisal. He has not done anything pertaining to it. He has also admitted that he doesn't have financing. He doesn't have the cash. He's given discrepancy in terms of what he's testifying, Your Honor. And above all, he was in breach. My client has testified as to the breach and the information that was given to him. My client has also testified as to the issues pertaining to just the Stonecrest matters and the fact that they were forced to enter into a plea in an absentia. And at this point in time, Your Honor, not only he didn't cure the defaults, he caused my client funds and resources to have to defend an action that they had no part in it. They didn't cause it. They didn't contribute it. They're not using the premises. It's all because of Mr. Michel's use of the premises. So that for that, Your Honor, we are seeking determination that my client gave Mr. Michel to be held valid and for him to be dispossessed of the premises. We're seeking possession, Your Honor. We'll make a motion to have a ruling on based on the hearing that has been already held, abundance of testimony as to the issue of citation, his knowledge of it, his lack of willingness to cure it, and then subsequent to that, determination and the course of action that my client has taken, which is proper in terms of when a commercial landlord finds a tenant in breach of a commercial lease. For that reason, Your Honor, we'll ask for possession of the property in 7 days, a writ of possession, Your Honor. You're not seeking money at this juncture of time, but should the tenant want to appeal this judgment, we would ask for him to be forced to pay a holdover rate that is based on the language of the lease. There is a holdover period, and overholding carries based on section 30, Your Honor, rental equal to twice the base rate. So if he seeks to, maintain possession post here, and we would ask for the rental rate with regards to an appeal to be at the contract value, which is equal to twice the base rent, due to the additional costs and issues that holding over would yield for my client, Your Honor.
Your Honor.
What is the base rent?
Your Honor, the base rent in this commercial lease is, I apologize, Your Honor, I'm gonna read that to the record in just a moment. Or Mr. Michelle, perhaps you can specify how much is the base rent?
2,500.
Yes, Your Honor. Section 7 of the lease, page 3 is $2,500.
And also, Your Honor, I don't know if I can talk, right? And the first notice.
I
they
can't
said-
read that, and you didn't.
No,
send
no,
it.
that's what I'm telling you. No, this one I already sent that to the court. The court has that one.
We don't have any of your. Go ahead. Don't read from the document.
Okay.
I'm not going to rehash that. Go ahead.
Understand. And the first letter that they sent me, they tape it on my door, and they say I was like $500. They charging me $500 for late fees, and then they charging me a total $2,500 and to failure to to repay expenses by the landlord. And so in the second, when they send me the letter so I can go to the hearing, and the letter say I'm zero. So I'm a little bit confused, because if I'm zero balance, and then now
They're not asking you. They're not seeking any sort of money judgment today. So we don't have to get into that.
Okay.
Okay.
But
They're just seeking possession.
all I know that, so I spoke to the lawyer, right, lately, but they asking me if they can pay me like 4 months, 5 months, and then so I can leave the
Okay.
property.
If
I have
you
an
can't get into
objection on that.
negotiations, I mean, I think it was probably a cash for keys, probably just trying to get you to vacate the property is my guess. That's probably what it was.
Wow. So if they don't allow you to buy the property, then you expect that they pay you to move. That's a heck of a deal.
Okay. I just want to make sure Ms. Harper is going to send me the exhibits from this. Mr. Amat, you sent them in to the email address.
Yes, Your Honor. We've sent them into the email, and then I believe our first hearing was with Clerk Davis, if I'm not mistaken. So I think all of that has also been sent to her in addition to the email on the notice.
So Ms. Harper has everything, correct? Is that correct, Mr. Amat?
Yes,
Ms.
Your
Harper?
Honor.
Okay.
Yes, and I'm happy to resend everything to Ms. Harper just in abundance of caution, but they've already been sent to the email on notice as well as Clerk Davis at the time.
It was like forward directly to Miss Davis. Because I
So
don't see, I
first sent
see it's,
to necessary ct1.gov and then subsequently sent to Mrs. Davis.
did you attach the case number in the email? 'Cause I
Yes.
can't see it in CT1. I see it in the exhibits tab in Odyssey.
And Judge, in abundance of caution, I'm gonna go ahead and resend it. And I'm also including Mr. Wilder, Mr. Michelle as well.
All right. So did that conclude? I guess that concludes the evidence in this case. Is that correct?
Yes, Judge.
Okay. I'm going to take this under advisement and I will issue an order at a later date. Okay.
Yes, Judge.
Okay.
Judge, my witness is excused.
Hold on one. Let me just make sure. Position number. This was position number 7. This is Mr. Michelle. Okay. All right. All right, everybody's excused. Like I said, I will take things under advisement and I'll issue an order. Okay.
Yes, Judge. Thank you
All
so
right.
much.
Thank you. You're all free to go. Thank you. All right, Mr. Ellis.
Yes,
All right, Mr. Ellis, if you could turn your camera on, please. Okay.
I'm here.
All right. So, Mr. Ellis, you're here on two motions. You have a motion to dismiss and a motion to stay the writ. I'm going to address. So there was a consent order back in this on this case. Let me pull up the order.
Sorry, Judge, I'm free to go.
Yes, sir. Yes, you are free to log off. Thank you.
Okay, thank you.
All right, Mr. Ellis, before I forget, if you could please raise your right hand.
What are we swearing to, ma'am?
I'm putting you under oath.
In regards to what? I don't know what's going on. We just got back on here and started
You've never
talking.
seen anybody put under oath. You've seen me put all these people under oath to swear or affirm you're going to tell the truth.
Judge, it's not that. It's just you just jumped straight into the conversation. I don't know what I'm swearing to or under oath of. I'm just asking. That's all.
I'm asking you to swear that you're going to tell the truth and nothing but the truth under penalty of perjury. Like
In
everybody
regards-
else you've seen today. In regards to your testimony today, sir. Sir, I'm not playing this game with you. You know
I'm not
that.
playing.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yeah.
Okay. All right. You can put your hand down. All right. There was a consent order in your case signed by both parties on August 28th of 2023. Said a writ would be available 11:59 p.m. on September 5th of that year, and that there would be a money judgment in the amount of $7,105.92. I was reading through your motion to dismiss and your motion to stay the writ. I'm going to ask about the writ first. Have any monies, has the landlord accepted any funds from you
Yes.
after the issuance of this order?
Yes.
Okay, tell me about that. When was it? How much was it?
So we tried to send the full amount that was expressed during the first court case back in August. It was $7,105.92. However, they declined to take the money, and then expressed to us that it should be $10,231.23 without proper documentation or explanation.
Were you still in the property?
Yeah.
Okay.
Yeah, we're still in property.
So,
And go ahead, man.
so if you're still in the so the order, the judgment that was issued back in August of 2023, it's basically an agreement to vacate by a certain time and a money judgment.
Okay.
It's not a payment plan. Okay. So basically, if they had
Wasn't a payment
accepted
plan.
money from you, the judgment amount would be different than the amount to stay most of the time. Okay. So if you went to them and offered them an amount of money, like you offered them the judgment amount, that's probably would not have been enough for them to agree to have you stay in the property. So they on that basis, they probably would have rejected the payment.
That wasn't the case.
Okay. So what happened?
They just declined to take the funds. As I stated,
So that's what I mean. Like, if they want you to move, they're not going to take funds from you if they want you to get out, because if they take funds from you, then they'd have to cancel the writ. So if
and
you
that's what I'm
offered
trying
them
to express
funds,
to you.
okay, when did they accept funds from you? Okay, who is this in the room? You can't be you're testifying. You can't be getting instruction from other people.
I'm not getting
Just-
instructed, ma'am.
You were talking to someone in the room with you. I heard her voice.
Ma'am, with all due respect, I'm looking at all of my documentation in front of me. I can show you.
Sir, I just heard someone's voice telling you something.
Ma'am, with all due respect, I'm looking at the documentation here in front of my face. Simple as that. I'm in my own home.
Okay, answer my question. Is there someone in the room with you?
No.
All right. All right. Again, so they accepted funds from you when?
See. I want to say September the 5th. Yeah, September the 5th.
So you approached them to pay and they actually took the money, deposited it?
Yeah, so I approached them to pay, the acting, property manager at the time. She voided the contractual agreement that we had here or there in that courtroom. It was agreed upon between her, my father, and the, acting attorney at the time. Also, there was a condition of, the mold to be, taken care of as well.
Okay, I just need to focus on that you offered them, when did they accept funds from you? Because that's really gonna be about whether the writ get canceled or not.
September 5th.
So they actually took funds from you?
Yeah,
Accepted,
they took.
deposited. I thought you said
I'm
before
sorry,
that
I'm
you
sorry,
tried.
I'm sorry. No, I'm sorry. On September 21st, they took funds. On September 5th, that's when Jorge detail. Yeah, so September 5th, she declined the to take the funds. I do believe before September 5th, had a conversation with her.
And on the
I
21st, they did take funds? You were
yeah,
saying
yeah.
okay, how much did they accept from you on the 21st?
September 11th. Yeah, it was September 11th. I'm sorry, man. Or no, I'm right. September 21st. She took $3,000 of the funds, and that was held for months.
They didn't deposit it, they held it?
Yeah, they held it.
Did they
Yeah,
ever deposit it?
I'm not sure.
Did they return it to you?
Yes.
Okay, so that was not accepted. That's not
no.
accepting the funds. They held it and then they returned it back.
No, actually, no, they didn't. It voided. They held it for so long, it voided.
Okay, so they did not actually, they were holding it, did not
Yeah.
actually deposit it.
Yeah.
It was a check?
Yes.
Okay, so at any other point, did they accept funds from you?
They pretty much just quit conversation. I tried diligently. This is one of the reasons why we brought this into court. We tried diligently to continue to provide funds. We tried diligently to get conversation. I actually had to have, because of my father, which is the leaseholder. We've had several different people communicate with these people.
You're not on the lease, sir?
I'm on the lease. Yeah. So
I'm sorry, you're Mr.
we
Joseph.
tried to send funds.
Joseph,
She
you're
rejected the fund.
Sir,
She
are you
rejected
Joseph? Sir, are you Joseph Ellis? Is that your name?
Courtney. I'm Courtney Ellis.
Courtney Ellis. Courtney. Okay, and you are on the lease?
Yeah.
Okay. All right, so you offered them funds, they held some funds, they didn't ever deposit the funds. At any point, did you give them money that they actually accepted and took and kept and deposited?
Forgive me, Judge, your phone froze. I don't know what you said after funds.
I'm just, it's so at this point, they haven't accepted, I haven't heard any testimony that they've actually accepted funds from you after
No,
this.
they accepted funds. And so they accepted the funds. We tried diligently to provide full funds. I already tried to give them the full funds. The lady, I don't know what happened with her, the management lady, they went through another person. Then they went from being that to just being mute. Then they went from that to a whole nother company owning them or whatever was going on with the property management. They assumed that all communication was broke. We've been in and out of the court trying to get you guys to adhere to get some type of mediation in between this. So as far as what we were supposed to do with the court, we did that. We came in there, we spoke to them. We spoke of two things that needed to be completed. The mold needed to be done, the funds.
Okay, well, the order in the case.
We had a certain date to provide the funds.
There's two things in the case. The order only states this is simply an agreement to vacate and a money judgment. That is all this is. That is what this order is, the one that's from August. So there's nothing else. There's no other order about anything else in this case. Okay, so someone is in the court in your
No,
room.
ma'am, no. He just walked. The
Waving.
person who's on the lease just walked into the house. I'm telling him to come in here so you can be present now.
Okay, so you're
What
gonna
you want?
testify?
Yeah, he might as well. He's the person on the lease.
Are you on the lease too?
She
Mr.
talks to
Courtney?
you. Yes, ma'am. Yes, ma'am.
Okay, are you on the lease, Courtney?
Yes.
Okay, you stated you're on lease. Okay, sir, so you are Joseph Ellis, is that correct?
Yes, ma'am.
All right, if you could please raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Okay, so this is what I have to do. The only thing I have in this case, I have an order that there was an agreement that you guys would be out of the property by September 5th at 11:59 p.m. and that there would be a judgment against you in the amount of $7,105.92. There was no, look, that's what the order says. That's exactly what the order says. And so there's no agreement that in the
Why
order,
would we have to
there's
exit?
not
Why
a
would we
pay
have
and
to
stay
exit?
agreement. There's
Why-
not a pay it. Hold on. I can show you the order. That's exactly what it says. It's not an agreement that they're going to take funds from you at any point. But if you can show me proof that they did actually take and deposit funds from you after at any point prior to applying for the writ, or I mean, if you can show me that they've accepted funds from you, then I can dismiss the writ. But if you can't prove that, I can't dismiss the writ.
Okay, well, give me just a second. Let me look at these forms.
Oh, it's his favorite game. Yeah, for real.
I'm reviewing the order you said real fast.
Can you guys see this? The order? What are you guys looking at? Can you
I
see
have this
the
form too.
Can you see the order on the screen here?
Yeah, I have the same one right here in my face.
Okay,
Thank
so
you.
what that says that you guys agreed to vacate and there would be a money judgment. It's not like an agreement that they're going to take funds from you or a payment plan or anything like that. That's what that is. So
Where do you see that it says that we would vacate, ma'am? Because we're still under contract. So
the
I don't-
writ of possession be issued on September 5th. It's the very first line, checked line. You will vacate on September 5th, 2023 at 11:59 p.m. That is the
How would that help me understand how, if we're in a contract, that if we came to court to pay the funds so that the writ could be removed and we continue
that's
to be
not
here.
what
So
this is.
how would
I'm
the
not sure.
contract? But how would the contract be voided, ma'am, if we are to pay
Because
funds?
the eviction terminates your lease.
But there's no eviction if the funds were to be paid.
No, if if they accept the funds, then I would have to cancel the writ. But if they've not agreed.
That's why we brought
Mr.
this
Ellis, stop interrupting me. There is no agreement here that they're going to take funds from you. And if they had, I'm just asking you to see if you have any proof that they've accepted any funds from you. And I'm not holding. I know you said you gave them some money that they were holding. They were probably giving you a chance to come up with the rest of the money. But like I said, this is a judgment and vacate. There's no payment plan here. They haven't agreed to accept funds from you while you're still on the property. Now, if you have moved out and then you went and tried to pay them some money, they'd probably take it. But if they're wanting you guys to move and keep the writ alive, they're not going to deposit or accept funds. But if you prove that they did, I can set aside the writ. But I'm not hearing any proof that they actually accepted funds.
Okay, so I have in writing of them asking for funds.
Do you have like some sort of cash, like a cash check, some sort of proof that they took money from you?
Yeah, I do.
What do you have?
Can the court allow me just a moment so I can grab the
Yeah, go get it.
Thank you, I appreciate
Whatever
it.
it is, go get it.
Just another moment, please. We're still looking. Hey, Judge.
Yes.
I need just a moment longer. I can't find it. Is it possible that I can
get it
What
off
is
of my
it that
bank
you're
account?
looking for exactly?
Can I
What
get it? The cashier's check that was provided to me.
okay, you have
I'm trying to get some type of receipt or something to show proof of that.
that shows that they cashed it, that they accepted and cashed
Yes,
it,
they accepted it. Yes, ma'am. They accepted it.
and it was cashed.
It was accepted.
How would you still have it? You're going to need to show proof that they actually cashed it, like
That's
they
what I'm
actually
trying to.
received it and cashed. Okay,
That's what I'm
this is
trying to
what I'm
tell
going to
you.
do. This is what I'll do. Okay, I'm going to give you. I'm not going to fully reset this, but I'm going to give you 24 hours to submit proof that they accepted payment from you. Okay.
That's cool.
Whatever you said, if whatever you send in, if it's not actual proof that they received and cashed these funds, then I'm not going to set the writ aside. Okay, I'm going to deny your motion. In terms of your motion to dismiss, I did not see any actual basis on your written motion to justify setting aside the entire case, as it is a consent order. But like I said, so I'm going to deny your motion to dismiss based on just it states no valid basis to dismiss the case. But I will, if you can show me that proof of that they did show, if you can give me the proof within 24 hours. It is 1:20. It would say it's 12:30 today. If you can give me by 12:30 tomorrow, Ms. Harper, can you give Mr. Ellis an email address that he can send that to? But if you can prove to me that they accepted and cashed funds from you at any point prior after that order, I'll grant your motion to stay the writ.
But can you please help me understand as to how is this order that you're saying that we went in there and talked to these people is expressing that we were to be vacant up
If
the
you're
home?
confused about that, sir, I don't know what to tell you. You can consult an
But why
attorney,
wouldn't
but
you?
it clearly states that you're going to be out, or they can apply for a writ
Where does
after.
it say, but where does it clearly
It's
state
the
that we
first
would be out?
line. It's the very first line, sir. A
Of
writ of
which
possession will
part?
be available on September 5th, 2023. If you guys have not vacated, I mean, that's what it means, that they will be able to apply for writ as early as that date. And then there
But
would be
that doesn't imply, Judge, that we were to vacate the home.
No, Judge, it doesn't mean what you say it means. It means what I interpret it to mean. You know, not what you've spent years on the bench upholding. No, it means what I feel it means.
It
There's no
absolutely
notification of,
100%. That's exactly what it says. Okay. I'm not, if you have other questions about that, I don't know what to say. You can talk to a lawyer, but that's
so
exactly what it says.
I want to bring up something also though, ma'am. So we had a court case with the same thing here for May 28th. And it says the same exact thing, and we paid the fees, and there's nothing stating that we would be told to
Sir,
leave the premises. But I'm
you're
asking a
clearly
valid
not
question,
understanding
Judge.
what this order says, and if that you can consult an attorney, but that's what the order in
Judge,
this
there's no
case.
need to. I'm asking a valid question though, Judge, with all due respect. I have
Mr. Ellis,
a previous document with the same thing, man. We paid it, and there was no vacate of the home. We was not told to vacate the home. Now, why would we come in there?
Stop. Mr. Ellis, the order in this case, if you show it to any attorney, it is clear that you agreed to vacate the property or a writ would issue and there would be a money judgment. I don't want to argue about it with you anymore. If you don't understand that,
No,
you're going
I'm
to have
not
to
trying to
figure it
argue
out.
with you, Judge. Don't
I'm
I have a
giving you
valid right to ask her?
Mr. Ellis, I'm not going to talk about it anymore. We've already
But why
addressed
not
it.
though,
The
Judge?
order.
Please help me understand as to why you're representing this company, and then you won't answer my
I'm
question
not
as far as
representing this company.
you are, man. Because
Mr.
isn't
Mr. Ellis, stop.
Judge, isn't the plaintiff supposed to be here? Isn't the plaintiff supposed to be
I'm
here?
hearing your yeah, they are.
Right. So
this
why
is
are we
your
even-
motion. So you are here and they're not defending it. So
But
you
they've
have
been
to, but you
called, so
have
why
to
would
show.
we continue?
Mr.
Judge,
Ellis,
please, with all due
I'm gonna
respect,
remove
Judge,
you if you keep
why,
arguing with me. If you
Judge,
keep
I am
talking
not trying
over
to
me.
argue.
Okay, I'm done. I'm done.
Judge, I'm asking a simple question, Judge.
No,
with
you're
all due
not. You're
respect, Judge.
interrupting me. Stop. There is an order in your case already. Frankly, they were already entitled to the writ based on failure to. There was also an order to pay rent to court that they didn't ask for a writ for. And then There's an order that simply states you're supposed to vacate, and there's a judgment. And the only defense you're going to have to that is if they accepted money from you,
And they
which I'm
did.
giving you 24 hours to
I
get
understand.
turn
I
it in.
understand.
Ms. Harper, can you please give us, please chat Mr. Ellis an email address that he can send that to?
I chatted
Really
him
fast,
by
Ms.
email.
Judge. I do like to say this. This case was continued 2 weeks ago because they did not show.
And
Now
I'm
we're here 2
I'm
weeks
not
later and
continuing.
they did not show, Judge.
Right.
So
And I'm
you're
giving you
handling the
chance.
case for them, and I'm simply asking you, if my
Unbelievable.
case
I
was
am
2
not
weeks
handling
ago,
the case. You have a burden of proof for your motions that you have to show. I can't just cancel this writ without having proof that they accepted
Judge,
funds. Okay.
if my case 2 weeks ago was to be seen with the other party's lawyer, and they continue that case because they did not show, why are we having this conversation in regards
Because
to
it is
the
your
dismissal?
burden. These are your motions, and it is your burden.
Yes.
Despite them not being here, you have to show that they accepted funds.
Okay, so
So
thank
send
you.
me,
You're
I'm
gonna give
giving you
us 24
24
hours.
hours. I'm
Yeah.
giving you 24 hours to show me that proof. And if you can send it in, I'm going to dismiss this writ.
Okay.
Okay.
And what
just
about
do-
the other
So
motion?
Ms. Harper's going to send it in there. She's giving
What
you,
about the other motion?
I'm denying your motion to dismiss that it doesn't present any valid basis to set aside the order.
And how though, Judge? I don't understand.
You need to
How does
consult
that
an
happen?
attorney. You need to
No,
consult an
I
attorney.
don't.
You
I'm
entered
good.
into a consent. Your father's entered into consent agreements. And if he needs to consult an attorney about why that motion is not valid, then you guys should do that. That's the order of the court.
And what motion are you referring to, ma'am, for my own edification, ma'am?
Okay, like I
motion are you
already
referring to?
said, motion to dismiss is being denied, and I'm giving you 24 hours to send me the proof that they accepted payments.
Okay, thank you. And I do want to say this too, and for the record, you're telling me that we're having this case after it's been continued. They don't
Mr.
need to be.
Ellis, I'm ending this.
I'm just saying for the
You
record,
can
ma'am.
go
You're
now.
saying
You've
we
already
don't have
made
to
your
have
record.
the plaintiff
You can
here.
go now, sir. All right.
So-
All right, that concludes the business for courtroom number 2. We can end.
She was done. That was it. She had her fill. That was a lot of nonsense. That poor judge. Oh, no, he doesn't want to get it. He wants her to magically just change the answers to what he wants them to be. Whatever would benefit him. Yeah, well, and she gets to deal with that all the time because she's one of the regular dispossessory judges. So that's not the first time she's dealt with that. And sadly, it won't be the last. Oh, yeah. Yeah, probably. Maybe a couple. Normally I go crazy with blurring out and blocking out all personal details and info and stuff. I didn't go overly heavily on that this time because this case was from a few months ago, and one of the properties was actively in the process of a sale, and the other ones had writs for possession. So yeah, there really wasn't a point in doing all that because they don't live there anymore. And it's all public record anyways, even if I did blur or block it all out, anybody could just look it right up. So, but yeah, oh, that was fun. What a wild day. Started off strong with that girl who got annoyed with the guy explaining to the judge that, he works for, what was it, UPS or something like that. And it was after he won. So, he's getting his motion to steal records. And he's like, well, I just want to tell you what this is all about, even though you didn't ask. And I don't need to. I'm still going to tell you. And Miss Little in the middle, she got annoyed. Told him to stop effing talking. And And then we went into Mr. I think his name was Mr. Edwards, who decided that it was a really wise idea to just, let his ex-girlfriend stay in the apartment with his name still the one on the lease. And then she turned it over to a friend of hers, and then, or son, maybe it was her son. And then the squatters. And so now he may be on the hook for the squatters have taken over. Don't ever, ever leave a place with your name on the lease. It's just all there is to it. And I might have the update to that one, but as you can tell, tonight's docket was really long. So I checked that date, and I've got 4 dispossessory court hearings from that date for his follow-up. So I'm going to see if I can find the update. But I don't know if he did show it or not, but that was the idea, that if he didn't show within 24 hours, then the writ stood. And that means, he's got to get out of there. And I don't think that's something that they'll announce. Like, I can check the next day, but they'd have no reason to announce it. The rest would be done, behind, off camera kind of thing with the lawyer and the judge. But, all right, guys. I'm super tired. I am going to go to bed, and tomorrow I'll get up bright and super early and get back to working on getting the merch store put back together. Hopefully eBay stops taking it down. That would be super helpful. And if y'all do order anything off the merch store, please go back into your eBay and do the rating it, and rate it really well, please. All right, guys. Thank you so much for coming and hanging out with me. And I absolutely am so, so grateful for our newest chat channel members. Oh my gosh. You made me so happy tonight. Katrina Rosmierek. Thank you. And tell your hubby early that I said thank you to him as well. I really appreciate it. I can't wait to have you guys come. Yes, Yvonne McLaren, honey, I'm so happy you made it tonight. I miss you all the time, love. I'm so happy you were here. And Mel, you're just amazing. You really are. Oh, that's exactly what I'm going to do, my sweet Rocky Lennon. Oh, Nana Laura. Well, now, Rocky Lennon, now the babies can sleep peacefully because you won't be laughing so hard you wake them up. Good night, Auntie M. I love you. I love you. See, I can say goodbyes because our beloved Sir Philip isn't here to chant. Good night, April. Good night, April. Good night, April. When he knows I'm tired. All right, guys. Be safe, be well, sleep sweet, and much love.